Well, hello everyone, and welcome to Uncivil Law. I hope you're having a great day as always. And we're here to talk about Karen Read with your friend in mind, Aussie Insider. How you doing?
I'm good. How are you? Hey, chat.
I'm doing fine. And we're here just to talk about how we feel about Karen Read, how we feel about the case, strengths and weaknesses of the case from both sides, what we think about any issues relating to it. Just kind of have a free form discussion, no particular agenda. So just try to talk a little bit about what's going on in Karen Read world. So, what do you
No.
think is going on in Karen Read world?
Well, I've kind of been a little out of tune. I caught the end of Jen's testimony, and I just caught up with the rest of it today because I was on the road. But yeah, that was interesting. So, what do you think compared to last year?
Well, I think on the whole, I'm more favorable to the prosecution than I was last year. I think Brennan generally has been doing a very good job with what he has to work with. He's burned by realities, but I think given the realities that he's burned with, I think he's been doing actually a very good job trying to present that evidence in a very linear and streamlined way. I found his opening to be, while a bit monotone, I found the story to present a lot of sense. So his
Right.
stage presence and delivery left something to be desired, particularly by comparison to Jackson. But Lally, for example, last year, it was just a lot of very dry and very banal, esoteric, and exacting facts with no particular connecting tissue that got you anywhere. It's just
Yeah.
like it basically is trying to like prove the entire case in the opening, whereas Brennan in his opening presented a very structurally flawless presentation. His stage presence needs work, but and then in terms of presenting the witnesses, I thought he's been doing a very good job in how he's presenting witnesses, staying strong with his best evidence. With like I hit him, and also getting that from the EMT and firefighters. So I think he's been doing overall a very good job, and I think the defense. I think Jackson, with the possible exception of Jen McCabe, I think Jackson has been overly aggressive. I feel like he's been fighting too strong for too little, and probably coming off as a bully. I prefer other members of the defense team. Alessi, for example, I find Alessi to be much better, in my personal opinion. Um, yeah.
Everyone loves
So
Alessi.
so far, I'd have to give things to the prosecution. With respect to Jen McCabe, of course, she just got off the stand after 3 days, and you know how you judge her or not, I suppose, is a little bit in the eye of the beholder. Um, but that's sort of my overall opinions thus far. I think it's been much better by comparison to the first trial for the government.
I think it is a much better trial. I do appreciate that Brennan actually told the story in opening statements. I didn't enjoy Lally just going through his 80
No.
witness list. That was boring as bat's poo. But yeah, Brennan actually did tell a story this time. So that was an improvement, I guess. And as you say, he's got lemons, so he's doing the best he can with a cart full of lemons. So yeah, I think all round it is a better trial. It's good to see. I appreciated Yannetti standing up to Judge Bev at least once there. That was good to see. But yeah, overall, I think both sides are doing way better. Although straight out the gate with three lying witnesses probably doesn't help much where the jury's concerned,
Well, I
right?
mean, you can remember that all the jury is supposed to assess is based on what they know in the courtroom. So their ability to assess, whether the opinions and strengths, truthfulness, weight of the witnesses is going to be based on what's in that courtroom. So one of the things I try to keep straight in my own mind is like, what do I know versus what the jury knows, which are not the same thing. In some ways, I know a
Right,
lot more than the jury
right,
does because I saw the first trial, and I've been
right.
following this case, reading about the case. So trying to assess the strength of witnesses, you know, I don't necessarily think that just because two people are you're telling a different story at two different times necessarily means it's a lie. Um, there's a lot of different factors that go into memory and how people think about stories. Of course, the energy of the moment in a crisis situation itself will impact how people remember things.
I guess it depends on how the defense's case in chief goes too. So if you've got already, your main witnesses for the
Mm.
or your star witnesses for the prosecution having been impeached multiple times, telling different stories at different hearings, then if you have something similar happening with the defense's case in chief where they're getting impeached, then I guess that has an impact. But if you don't have that same thing happening, then I just wonder if the jury's going to be scratching their heads that one side's being far more truthful.
Perhaps, I mean, it's up to the jury to decide whether or not it's an issue of truth or not, or what is going on
Mm,
there. Um, but the biggest problems for the Commonwealth, of course, are yet to come. Their biggest problems are relating to the police investigation and what was done there and not done there. Their biggest problems are with
mm,
evidence collection, with the solo cups, not finding the pieces of plastic during the initial searches, the fact that evidence was running around in someone's trunk for a month, the fact that when evidence was turned over, there were no logs reflecting who gave what to whom, the fact that when the labs were testing things from solo cups, they didn't determine which cup it came from or how, the fact the medical examiner was unable to determine a cause of death as homicide, and so on and so on and so on. So this
right.
Commonwealth's problems have not been exposed in that courtroom yet, which makes sense because if I'm the Commonwealth, primacy and recency, I want to start as strong as I can, with as much good as I can,
Mm,
because I want to prime that jury with all the really good stuff, and then I want to ideally finish as strong as I can, and sort of anything else I throw in the middle somewhere to varying degrees. That's how you sort of want to deal with things strategically, if you can.
on that topic, do you think they're
I don't know
going to
how
call
I
Proctor,
don't know how they
or do you think they're
can't
going to avoid?
call Proctor. That's the problem if I'm the Commonwealth. It's like, how do I not call Proctor? Because another thing as a lawyer is you want to get ahead of bad information. It always is better. It's always better
Right.
for you to expose bad information than your other side, because you get to control it, and you get to control how, when, and
Yeah.
why. And you also get to control the presentation of it. If you wait for the other side to do it, they're going to make it as ugly as they possibly can, because that's their job. So if I'm the Commonwealth, I don't know that I have any
Yeah.
choice but to call Proctor. Proctor is a massive liability, but if I don't call him, I don't know how the defense doesn't, and how that just doesn't go disastrously for me. So I think I'm almost
Yeah.
forced to call Proctor.
So you're probably going to do the same things they did last time. Call him up, get him to read his own damning text messages, and try to get it all out
Yeah,
in front. Do you
probably.
think?
I mean, I they held Proctor really long last time, and I think that was not necessarily ideal because Proctor is such a bad witness for them. So if I were them, I'd try to call Proctor somewhere more in the middle of this thing, and because he's such a disaster, and then try to, like, hopefully the jury kind of forgets, as I ideally have better witnesses, to it's the
Get
sandwich
him
it's
out
the sandwich method. I put
the
the shit
first
in the middle
time.
and hope you don't notice. Yeah.
That's what I was thinking too. The same kind of thing. Um, so yeah, but they're putting their star witnesses up first that they know told three different stories so far, or four if you count the Fed investigation. But um, I feel like that's going to be like so far back in the timeline by the time the jury's deliberating that they're probably
Yep.
not going to remember it unless you drag them back up in the defense's case
Yeah, that's
in
probably
chief.
right. I mean, it's going to be a long trial on its own terms anyway, so the jury's ability to remember any specificity is going to be challenging. Even with notes, that's challenging, just because there's just a lot of information
Mm,
for them to comprehend. And so to the
mhm.
extent that there are inconsistencies, and to the extent you think those inconsistencies are a problem, then by getting them out earlier, the jury is less likely to focus on those things and more likely to, um, just focus on other elements that are, present themselves.
Do you think Canoni will let them take their notes into the deliberation
Yeah,
room
were they
this
not
time?
allowed to last time?
I think they were not allowed to last time. I don't right remember, but that's what people have been saying. I'm pretty sure I missed, sorry, the end of that whole thing before they deliberated. So I ended up going back and screen recording the mistrial and the jury instructions, but I don't quite remember if they were allowed to
They
take the
should have been.
notes
It's
in.
pretty. I don't know of rules that would allow for notes and them not to be brought into the jury room. So that would be really odd to me if that were true. Yeah.
Hmm.
Someone asked in chat whether or not Proctor can plead the fifth. It's possible, but then you could have a hearing relating to that, whether and to what scope he'd be allowed to testify. So if he tries to invoke the fifth, it could become a whole mess with the issue. But then again, like even if Proctor pleads the fifth, you're still back into the same problem as the Commonwealth. It's like if he pleads the fifth, then the fact that he's not there um, becomes a problem that can be exposed by the defense as well.
So because he's just, why would he plead the fifth though? Because he's now a citizen
It's
and not
irrelevant.
a
I mean,
trooper anymore.
it's
So I don't
irrelevant. The
quite
Fifth Amendment would
understand.
apply anytime that there's criminal exposure, whether you're a police officer or not. So the question would be whether or not he
Right.
has criminal exposure relating to anything that he would be able to
Yeah.
testify to. And I don't know. I haven't worked through the problem, from his point of view to try to figure out whether or not he has any Fifth Amendment protections that would be available to him.
Well, the only criminal exposure I could think of is if he was the one who actually broke the tail light. And he's not going to admit that on the
No.
stand, is he?
Yeah, I don't know the answer to
So I
that
don't
question.
see.
I mean, someone just asked, can he plead the fifth? I'm like, well, possible. And then you'd have to have a whole hearing about the scope of the questions and everything, and it could become a thing. So it's like, yeah.
Yeah.
So I don't know.
Yeah, but yeah, that question from me was to whoever asked that question, because I can't see the chat right now. But whoever asked that question, that would be my question back to you for what?
I don't know.
So I don't think he's going to admit to anything on
No.
the stand, is
Tony
he?
P asked about qualified immunity. Qualified immunity doesn't protect you from criminal exposure. It only protects you from civil exposure. So qualified immunity doesn't get you anywhere in a Fifth Amendment analysis.
Right.
So yeah.
Yeah.
But yeah, I mean, so those are a lot of issues there. So what has been your experience with like the Karen Reed community in general, both during the first trial and I suppose now? How has the Karen Reed community, from your perspective, been responding to things?
Uh, uh, well, as far as my exposure to them, especially on my channel, like through comments and interactions that I have with them, there there's definitely a lot more people who are on board this time than last time. I'm seeing the polls actually add up to pretty much the same thing. All this division in the community that they're trying to say is there, like the mainstream media says, oh, the community's divided, but it's actually not. It's still around the 90% think that she's innocent. So I don't see the 10% on my channel. They don't bother with me for some reason. But I do see them on X, obviously. They're all over X. They still seem to be in the minority. So I don't actually understand where we get the communities divided sort of uh, tagline from when the media is talking
Yeah.
about it. Because I would suggest that 90% in favor of Karen Reed is not divided. It's quite the opposite to
No, I think
divided,
so.
wouldn't
I
you?
think I think there's division only. Well, from my perspective, I think my perspective of some of the witnesses has not necessarily been the same as some of the other members of LawTube. Not that I've been watching their content, but people like basically report back to me. And for example, I think that other members of LawTube have been more critical of the prosecution and more favorable to the defense than I've been. And also, for example, I took a lot of umbrage with the suggestion from Jackson's like, well, were you telling the truth, or are you telling the truth? Are you telling the truth, or are you lying? And I'm like, well, there is technically a third option. It's just because there's a difference between it being true and false and it being true and a lie. For it to be a lie, it has to be knowingly false. So the fact there's inconsistencies doesn't mean it was necessarily a lie either time. So I object to it as a false dichotomy. But a lot of other people on LawTube, as my understanding, were like, no, she's just a liar. And I'm like, well, I don't know whether or not she is or not. There are other possibilities here. But, I think there's a difference in perceptions of the strengths of the case.
I think she got some professional training this time, because just the way that she responded, like she kept her temper under control, so that was different. I just think she's got a lot of training this time. So I noticed, I'm talking about Jen, that is. I noticed that when she had yes questions, like it was a yes, or she'd finally get to the yes, she'd look at the jury. But when she was trying to avoid answering a question, she was trying not to look at the jury. So, whereas last time she just looked at the jury like pretty much while she was talking. So I feel like she's maybe got herself some professional coaching there.
Have you found any particular communities in particular to be interesting beyond LawTube? Any particular forums or sites that you found or particular creators or commenters you found to be particularly useful in understanding the case?
Yeah, absolutely. In understanding the case to begin with, I absolutely referred to Aidan Carney a lot. His website, his blogging site or website, journalist site. I'm gonna say the wrong thing here. But yeah, I absolutely looked to him. But that was because I knew he was in direct contact with the team, so information he was coming out with was closest to the source. So in the early days, yes, but right now I'm much like you. I'm so flat out keeping my own channel, and then I've got to watch to do the mashups, which everyone
The
loves and
mashups are the
demands.
mashups are
They're in
interesting.
high
I always
demand.
enjoyed those last year, watching various people's reactions. I always enjoy watching what
Right.
people clip of me and my reactions and how they interpose it. I find that kind of stuff interesting. It seems like I haven't
Yeah.
been as
So
many
generally,
compilation
what I'm
clips this
seeing,
year as last year. I don't know if that's because I'm not telling people what they want to hear. Maybe it is because I think
no, not at all. I'm looking for the funny stuff, so things we can get a laugh at, because it's such a serious, it's really serious content. You need to have that moment where you're having a laugh about something, or else it just is all serious and stressful. And because I'm watching it all day, every day, and then I'm making clips about it all day, every day, and I'm making my own videos about it all day, every day,
no
it can
doubt.
just be a
Yeah,
drag,
I
like
understand
drags you down.
completely. You don't have to tell me, man. I stream all day, then I try to put out edited stuff on top of that, and try to do shorts and stuff like that. Man, it's a lot of day. It's a lot of time for me too,
Yeah.
man. So I totally appreciate what you're saying. Yeah.
So generally, when I'm looking for stuff, I'm looking for the funny bits where we can get a giggle out of, how that person responded to that particular thing. And then I'm trying to build a theme too with the originally, I think the first few mashups that I did were all over the place. They weren't really on topic. It was just clipping the funny reactions to whatever. And people didn't really like having to hear the same thing repeated over and over to see the reaction. So I've like honed it down now to, all right, here's the topic, who had a great reaction to it, and that's the 10-minute clip that we're doing today. But if you had a good reaction to some other part, then I'll do that in another. But then what often happens is someone who has a great reaction to something, which I think's hilarious, nobody else reacted to. They're all like heads down taking
Yep.
notes. So,
We'll react to different
so
things. I thought I had some decent reactions with respect to the last witness, that poor you know, chemist from the lab, because she was saying things and I was like, why is that true? Or how's that true? And that's not how math works. And why are you making these assumptions, and so forth and so on. So
well,
I had a lot of questions that were not being answered.
great. I'll put a note here right now that the chemist is going to have some good reactions. I haven't watched everybody's reactions to it. I just got on for the last bit of Jen's testimony. So my grandmother had a stroke, and so I had to leave to go to Brisbane. and then I got broken down halfway and had to come back. So I missed a little bit and I'm behind. So I'm still on opening statements for mashups, but I do have a note here now to cheer out Kurt for the chemistry
There's some
actions.
good stuff in there, and some of my frustrations with the Arca stuff was interesting. I'm like, oh, I was like in a heart attack. Like, are we really doing this? I think there's actually probably some good reactions relating to the Arca stuff, because my understanding was a lot of us were like, what the fuck is this? When, you know, they were basically trying to exclude the Arca people. Are like, we were all just completely dumbfounded by the fact that we were at that
Yeah.
point, because it doesn't make any sense.
Right. And on the Arca thing, like Pep just dragged that out so long. Was there any point where you thought she's not going to allow
I thought it was a
Arca?
strong possibility, because that was the way a lot of the things were being teed up.
I kind of felt all the way through that it was just a PR stunt, because she didn't actually raise anything where I thought that is not going to violate due process or violate Karen Ree's right to have an expert on any particular topic, especially this that's exculpatory. So I kind of felt like she was always boxed in, but I also felt that if she didn't let the Arca experts in, the defense
Oh
would have
yeah.
immediately
I mean, I mean, that's
filed
like,
an
that's
appeal.
point one of a future appeal brief, excluding ARCA. That's such a huge deal and so
Right.
consequential. And I
But as a strategy, I thought that you would pause the whole trial. You do the interlocutory appeal, even though it's got zero Buckley's chance of being accepted, but you would do it just to pause the trial and kick Bev in the butt, because that's the one thing she doesn't want is the trial to be paused. So I kind of felt like they had her over a barrel with the ARCA and that she didn't have much choice unless she was going to pause the trial.
Yeah, absolutely. But there's still some possible shenanigans you have to be had, because she had that little line there at the end where it's like, Brandon, if it's too much, if you need help, feel free to file another motion. So all that good stuff. I'm like, okay.
Whatever. On that note, actually, we're doing a. Did you see Carl Steinbeck's video or stream he did? I think it was yesterday or the day before. Scoring Judge Bev according to the
No, I
SJC
hadn't seen that. That sounds
rules
interesting.
of judicial. Yeah, he seems to be like really on the ball. Like I just find it really interesting that not too many of the law tubers are going down this path. I'm not sure why, but I've been watching, how Bev's ruling and why she's ruling and whether she's being fair to both sides and whether each ruling's fair to both sides. And I've put out quite a few videos expressing my opinions on that. But having somebody else do it who's in that field makes it a lot easier to sort of square up where I'm coming from or not, or where I'm coming from is wrong, if that makes sense, because I'm not in your field. So I know as a person who has rights, and not even the rights that you guys have, we have a lot less than you guys do over there in America, but as a person who has rights, I'm looking at it from that perspective when I'm looking at the judge. Whereas he's in that field, he's very experienced at appeals and stuff like that. So the other person I take a lot of notice of
She's
is
great.
Andrea Burkhart, but she hasn't, right, specifically because she's in that field, the appeals field. But she hasn't been keeping an eye on, the list of appealable issues where I have, and Carl Steinbeck's on the ball with that. But the other day he did a judicial scorecard, like you have a report card after you finish school. Something like that, but
And
comparing it with
how'd Bev
each
do?
point in the SJC. Bev
Oh
scored an
dear.
F across the board by Carl, but what I decided to do was turn it into a public interactive and see how the public scores Bev. So that's what I've been working on for the last couple of days. For your audience or whoever's listening right now, if you want to be participate in it, it will be I will post it in my comments, and I'll send Kurt a link if he wants to post it in his comments, so that you can
Sure,
go
why
and
not? It'd
participate
be
in
fun for me to
scoring
walk
judges.
through. It'd be interesting to see how I do. I could do it live and see what score I come up with. I'll try to be fair. So I don't know that I'll necessarily come up with an F, but I don't imagine my score is going to be great. But I'll try to be fair.
Well, it's actually live
Let's
right
do it.
now if
Let's
you
do it
want
live.
to.
Let's do it. See what we got. Give me a
Let's
link. We'll
do
put
it
it up on
live.
screen. It'll be fun.
All right, let me find the link. I'll just shorten that so that I can put it in here for you. Okay, it's in private chat. So the biggest part of the job was connecting it to a spreadsheet and then connecting it to results. So when you're finished, it should give you the link for results. Let me just check. Yep, we're good to go on the results.
I'm trying to find out where the private chat is in this thing because I forget this. I don't use this. Oh, there it is. I see it now. All right, let's pull this up. All right. The Justice Beverly Canoni business card. Very exciting. All right. Let's see what we got. Let's share the screen. And
Be interesting to see how it looks at your end, because I actually haven't had a look to see how it looks on any other screen.
all right, we're doing this from the Business at Uncivil Law LLC email account. Okay, that's cool. All right. Score for 2.1.
Sorry.
The duties of judicial office as prescribed by law shall take precedence over all judges' personal and extrajudicial activities. I mean, there's no evidence of personal extrajudicial activities being the problem. So far, so good. To ensure that judges are available to fulfill their duties, judges must conduct their personal extrajudicial activities to minimize risk of conflicts. There's no personal or extrajudicial activities that create a conflict here. Although it's not the duty of judicial office prescribed by law, judges are encouraged to participate in activities that promote public understanding and confidence in the judicial system. I mean, she had that whole, law day where she brought members of the public in to try to instill confidence. With respect to time devoted to personal and extrajudicial activities, the rule must be construed in a reasonable manner. Family obligations, illness, and emergencies may require judges' immediate attentions. Attending those obligation situations is not prohibited. I'll give her an A because, I mean, there's no evidence that there is any personal or extrajudicial activity that's creating a conflict in this case. So I will give her an A.
I expect the chat would disagree with you there, but
The
they always
chat can
do.
think what they want. I'm going to give my opinion. Why I choose this rate? There is no evidence of personal or extrajudicial activities that create a conflict. Okay. Rule 2.2, impartiality and fairness. This probably isn't going to go as well. A judge shall uphold the law and perform all duties of judicial office fairly and impartially. To ensure fairness and impartiality and fairness, a judge must be objective and open-minded. Although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves the law in question. When applying and interpreting law, a judge sometimes makes good faith errors of fact or law. Errors of this kind do not violate the rule. In the absence of fraud, corrupt motive, or clear intention that judge's conduct was in bad faith or otherwise violates code, it's not a violation of the judge to make findings of fact, reach legal conclusions, or apply judge laws the judge understands. It's not a violation of the rule for a judge to make reasonable accommodations to ensure self-represented litigants are provided an opportunity to be heard. This is challenging to be fair to her because I have to be as impartial as the rule is asking me to be about it. So I want to be impartial. All right. So with her ability to interpret and apply the law in a fair and reasonable way, I mean, she certainly makes a lot of rulings that are legally correct. Her media,
She's made a few.
yeah, she's certainly made a few that haven't been. Her objectivity leaves a lot to be desired. The way she treats the defense is not really fair. Yeah, I'm gonna give her a D. Yeah, it's not going great. Her continuing
Right.
hostility towards the defense is mind blowing by comparison to how she treats the prosecution. Yeah, not great.
It's pretty much what that's pretty much what I
Rule
wrote too.
2.3 Bias, prejudice, and harassment. A judge shall perform the duties of her office, including administrative duties, without bias, prejudice, or harassment. A judge shall not, in the performance of duties, by word or conduct, manifest bias or prejudice, or engage in harassment, including bias, prejudice, or harassment based upon person's status or condition. That's not why she's biased. That's not the problem. A judge shall also not permit court personnel or other subjects to judge discretion control such behavior. There's no evidence that that's true either. A judge shall require lawyers in the proceeding before the court to refrain from manifesting bias or prejudice or engaging in harassment against witnesses, parties, lawyers, or others, including bias based on personal status or condition. There's no evidence that anyone is biased for those reasons. The rule does not preclude judges or lawyers from making a legitimate reference to personal status or condition when relevant. A judge who manifests bias or prejudice or engages in harassment and proceeding impairs the fairness of proceeding and brings the judiciary in disrepute. A judge must avoid words or conduct that can be reasonably perceived as manifesting bias or prejudice or engaging in harassment. As used in this rule, status of condition includes race, color, sex, gender, religion, nationality, national origin, ethnicity, citizenship, ancestry, disease, age, sexual orientation, marital status, socioeconomic, political affiliation. There's no evidence of bias for any of those reasons. As used in the rule, examples of manifestation of bias or prejudice include, but are not limited to, epithets, slurs, demeaning nicknames, negative stereotyping, attempted humor based on stereotyping, threatening, intimidating, hostile acts, improper suggestions of connection between status and condition crimes, and irrelevant references to personal characteristics. Even facial expressions and body language convey an appearance of bias. As used in this rule, harassment is verbal or physical conduct on the basis such as those limited in comment 2. Well, there's no harassment because there's no bias within the meaning of comment 2. There is no evidence of bias within the meaning of comment 3. There's no evidence of the judge showing through words or bias or prejudice on any protected characteristic. So when they define bias, prejudice, or harassment within the meaning of the rule, as defined by the rule, she has not demonstrated any of those characteristics, so she gets an A. She has not shown any bias for any of the reasons prohibited by the text of the rule. External influences on judicial conduct. A judge should not be swayed by partisan interests, public clamor, or fear of criticism. Well, she's definitely not being swayed by any of those things. That much is damn clear. A judge shall not permit family, social, political, financial, or other interests and relationships to influence the judge's conduct. There's no evidence of family, social, political, financial, or interest influencing her conduct. A judge shall not convey or permit others to convey the impression that any person or organization is an influence. There's no evidence that there's anything like that. An independent judiciary requires judges to decide cases according to law and facts without regard to whether the laws are popular with the public, media, government officials. Confidence judiciary is eroded if public judicial making is perceived to be subject to improper inside influences. She gets an A. There is no evidence the judge is being swayed by public sentiment. Rule 2.6, ensuring the right to be heard. A judge shall accord to every person who has a legitimate interest in a proceeding or that person's lawyer the right to be heard according to the law. A judge shall make reasonable efforts consistent with law to facilitate the ability of litigants, including self-litigated litigants, to be fairly heard. She never denies either side the opportunity to be heard. A judge may encourage parties and their lawyers to resolve matters in dispute, and in accordance with law may participate in settlement discussions, but it shall not act in a manner that coerces any party. She hasn't done anything like that. The right to be heard is an essential component of a fair and impartial system. Preserve right to be heard. The judge has an affirmative role in facilitating the ability of every person who has legal interest to be fairly heard. Judges make reasonable accommodations to help self-represent. She's not self-representative, so it's irrelevant. Judge shall be careful. Do not get self-representative. It's irrelevant. Circumstances, accommodations, self-representative. It's irrelevant. And then they say, in other circumstances, accommodations may include constructing pleadings. She's done nothing relating to pleadings. Brief information proceedings. She did that as a matter of course. Attribute neutral questions to elicit or clarify. I mean, she sometimes rephrases the question, but that's not like particularly problematic. Modify the manner of order taking evidence. No evidence of that. Attempt to make legal concepts understandable. She certainly tries. Explain the basis for ruling. She certainly does. And make referrals as appropriate to any resource available to litigants. A judge may encourage parties and their lawyers to resolve matters. She's done nothing to encourage that or discourage it. Judges must be mindful of effective police discussions. So within the meaning of this rule, has she done anything that would inhibit the ability of either side to be heard? No. She allows everyone to speak as much as they want. The judge allows both sides full ability to present any and all legal arguments. Great. Rule 2.8, decorum.
Are we watching the same trial? I'll zip it to you.
That's all right. If you want to interrupt, I've been talking for a while.
I don't want to influence anything. I'd rather you finish first, but then I'll ask you questions afterwards.
Rule 2.8, decorum, demeanor, and communication with jurors. A judge shall require order and decorum. A judge shall be patient, dignified, and courteous to litigants, judges, witnesses, lawyers, court personnel, others who the judge deals, and shall require similar conduct. A judge shall not commend or criticize jurors for their verdict. The duties imposed on all proceedings is not inconsistent with duty of rule. Commenting on jurors for verdict, which she hasn't done. A judge is not otherwise prohibited from law may do so. Yep, she gets an A. Yep. The judge has provided for decorum and has not made statements impugning the jury for their verdicts or lack thereof. Rule 2.9, ex parte communication. I'm just going to go ahead and skip that. There is no evidence of ex parte communication. So she gets an A because there's no ex parte communication. There is no evidence of ex parte communications. Where am I watching from? I am watching from the great state of Texas, and I will submit that form.
So if you follow that link, it just shows you the results, but you're the only one that's filled it out. So
yeah. So far, so good. So yeah, she only really got bad points for one thing really relating to fairness. So yeah, otherwise she gets A's across the board based on the way the rule is written and my reading of the rule. So that is my opinion.
Nice. So are we watching the same trial? So. Some of the things that you thought there was no evidence of. Sure. Is it okay if I challenge you on some of that? We don't need to argue over it, but I thought cutting off the defense in the middle of their trying to get things on record was like a big no-no as far as SJC goes. And I may have misinterpreted where that fits in on that on those questions.
Well, like when?
What do you think about that? Like every time they open their mouths. Basically, the defense wants to get things on the record, and then she will cut them short. She never interrupts Brennan. She never cuts Brennan short. She knows what Brennan's going to say from start to finish, but she never interrupts him and cuts him short. But as I said, I may have misinterpreted which of those SJC questions fitted that specific scenario.
Yeah. Sweating Bolt says Uncivil's trying too hard. Well, if I'm trying too hard, I'm doing something right, my friend. That's all I have to say about that. I always like to try my best. So if I'm trying too hard, I'm doing something right. I mean, I have found her to be very biased in her rulings. I found her to be biased in her treatment. I found them to treat them unequally. But when the defense wants to make an objection or have sidebar, she seems to grant those on equal terms to the prosecution. I haven't seen the defense, say, that they want a sidebar, and the judge always says yes. Basically, she always says yes for the opportunity to be heard. The defense files their motions. She hasn't prevented them from filing motions. She'll deny them, but in oral hearing, she's certainly a lot harsher with her questions, and she's a lot more more acerbic to the defense. But I haven't really seen her say, like, that they're not allowed to make an argument, or um, that she's just very aggressive towards them. But I haven't really seen her cut them off that I can remember.
So if she's aggressive towards them, but she's not aggressive towards the Commonwealth, isn't that
Sure, it
bias
is
in
within the
itself?
meaning of some rule. Yes, it might be, and that's why I scored that one rule accordingly. I was trying to reach each rule under its own terms, based on the wording of the rule.
Right. So that's why I was asking. I may have misinterpreted where that goes. So, and you're definitely the better person to be reading those rules because that's
I
your
mean, I'm not
job.
particularly familiar with the judicial canons, but like we could go back to like the rules. Like, okay, so 2.1, like, is there any evidence of personal or extrajudicial activities that's impeding things? I mean, no. I mean, that's not the problem, right?
Well, the two things that our audiences are going to point out is that she did rent her apartment to, her beach house to one of the McAlberts, and the other one. What's the other one? I had to. What was the second one? Oh, her brother represented Chris Albert when
Yeah.
he ran over someone.
Now the chat is pointing out
and
correctly that she
fled.
did deny a sidebar, but she denied the sidebar because she granted the objection. Right? The purpose of the sidebar was for the purpose of an objection, and she told the prosecutor to move on. So she gave the defense what they wanted without the sidebar. That's what happened. The defense wanted the sidebar because they objected to the question. They wanted to approach to raise the objection. The judge just said move along. So she granted the objection without hearing at the sidebar, so the sidebar was not required. So I mean that's just what happened.
No, that's not one of them. That's not one of them I would have considered, but so with giving precedence to the duties, let me tell you what I answered for that.
No, she didn't. Well, that's what I heard. That's what I saw. That's what I saw in the trial. That's absolutely what happened. Yeah, that's what happened. She made the defense.
I agree. That's what happened. Yes.
Yeah, that's what happened.
Because she was granting it anyway.
So it was moot.
So my complaints for the first rule were Bev hates the public. She's got a friggin' buffer zone so that no one has to listen to the public. So they can't be anywhere near the court. So I wrote Bev hates the public. She quits early and short weeks. Those were my complaints in this first one as to her precedence of the duties of her judicial office.
How is it not taking priority with respect to her personal and extrajudicial activities? That is the rule. Like, it shall take precedence over the judge's personal extrajudicial activities.
Well, if you're quitting early, if you've got a short week or you're quitting work early, that's for extrajudicial activities.
No, not necessarily. It could be for legitimate jurisprudential reasons. Like, for example, they didn't have court on that Thursday because it was a holiday for Law Day. It was pre-scheduled. With respect to half days that they have, I don't know why they're necessarily half days or what that's due to. So I'd have to know more about the reasons why those are being done. I don't know the answer to that question, but it's not inherent.
And it'll be interesting to see if she does it through this trial. Like, if she had stuff on with the last trial, or other people did, or any of the jury did, I would understand that. And it'll be interesting if she does it this trial. I might score her differently if she doesn't do it as often. She denied
Karen headphones. Does Karen have problems with her hearing? Is she partial?
She wanted to be able to hear. She wanted to be able to hear the sidebars, But instead of giving her headphones, she compromised with
Yeah,
carrying
so
candy
then
at the sidebar.
that gives her what she wants. That solves the problem, right? It's like, no, I won't let you be at the side. I won't give you
Yeah,
the headphones, but I'll just let you be at the sidebar so you can hear it. So again, it's like
yeah,
she gave her what she wanted. What she wanted wasn't the earphones. That wasn't what she wanted. What she wanted was the ability to hear it. So they got her what she wanted. So
yeah.
like your chat's objections are overruled. Your objection is overruled.
Overruled. Chat, you've been overruled. Yeah, so that was for my first one. For the second one,
She's 50%
hang on, let
deaf.
me get
I've
the
never
right
heard that
screen up.
before. She's deaf. Yeah,
Yeah, I
I've no
hadn't heard
knowledge of
that
that.
either.
If she is in fact 50% deaf and she's being denied hearing aid because she doesn't have the ability to hear, then yeah, that would be a problem if that were true. But that's the very first time I've ever heard that. So I have no knowledge relating to that.
So on to question
She wanted to be
2.
able to
I
hear
pretty
without
much
getting up
answered
and
that the
down.
same way.
Well,
Oh,
but she has the ability to get up and down. I mean, I've seen her get.
she does.
She
Some
walks into
days.
the court every single day. She obviously gets up and gets down in order to
Mhm.
get in and out of the courtroom. She obviously gets. She has the ability to walk. So, like, yeah, your objection is overruled. Like, she even under the Americans with Disability Act, we only have to give reasonable accommodation, and she's being accommodated reasonably. She can hear at the sidebar. That is a reasonable accommodation. So your objections are still overruled. I think Chad is reaching because they don't like my answers. Chad can fuck off.
Oh dear.
All right. So like now, this is the one I think I
Question.
gave her the most problem on was on the ability fairness, right? Because I'm like D,
Right.
right? This is where she like lost the points because like,
Yep.
okay, no, is she
Yep.
impartial in fairness? No. Has she like is she, you know, is she impartial? No. She treats the defense like shit. So like I gave her like a D because it's basically pretty shit. She's on disability. Disability for what, chat? Right? Disability for what? And what is the nature of her accommodation? So like, yeah, she's on disability for what? What is the nature of her disability? Is her disability or hearing? Is that the problem? If that's the problem, then great. If it's not the problem, then what accommodation do we have to give her with respect to disability? You have to be precise about this. This is law. We have to be precise. Precision is good. She has
So
MS.
I agreed with you
Fantastic. She
on
has
number.
MS. In what way is she not being accommodated for her MS in a way that she should be? How is her MS not? How is her MS inhibiting her in a way the judge is not giving an accommodation for? If your answer is because she has to get up and down, she obviously has the ability to walk. She literally walks into the courtroom every single day. She walks out of the courtroom every single day. She gets up and gets down. She walks to the courtroom. She gets out of the courtroom. She obviously has the ability to walk. So she obviously doesn't need an accommodation with that respect. So no, just no. So, I mean, we can keep arguing about this, but I'm just going to keep giving you the same answer every single time. So, I mean, we can keep arguing about it, but I'm not going to tell you what you want to hear. That's not how I roll. I'm going to give you my best answer. You can try to tell me why I'm wrong, but your answers don't make any sense. So nothing you're saying is persuading me. Sorry, Judge Mueller ain't. Judge on Civil's not having it. Judge on Civil says no.
For the record, I agree with you. She's able to get up and
Right.
down, and that was the
Right.
compromise.
Yeah. So yeah. So yeah. So okay. So like the impartiality is a problem. So rule 2.2. All right. In terms of like manifesting. Okay. Okay. Yes.
Hang on, go back to 2.2 because I had two more. I believe she's violated due process several times, and that is due to her bias. And I believe I agreed with you on the continuing hostility between the defense, the contrast between the defense and the
Oh,
prosecution.
old bag in chat says
But
it lacks empathy. Ooh, it lacks empathy. There's a legally persuasive argument if I've ever heard one ever before. It lacks empathy, and that means it's a violation of some rule somewhere. That is definitely not how that works. The judge is definitely not required to be empathetic either way. She's only required to obey the law. She's not required to have empathy for anybody. She's just required to do her job, man. She doesn't have to feel anything. In fact, there's probably a lot of great judges who are psychopaths, but I digress.
So on the violation of due process, would that have actually fitted into the second rule
Well,
here?
that if there's
Where I believe
okay,
she's violated
in what ways do you
process.
believe
So
she's violated due process?
where's my list? I can't think of them off the top of my head, to be honest. So
Ellie says I don't
the
get to dictate others' impact from their illness. If I'm a judge, or for that matter, an employer, I only am required by the Americans with Disabilities Act to give reasonable accommodation. I'm just telling you the law. I'm reading the law. So you have to tell me what the disability is, and then I only have to give you a reasonable accommodation for it. So you actually do have a burden as the disabled person to, first of all, tell me about the disability, tell me how it impacts you, and then I only have to give an accommodation relative to the disability. So that's the law. That's the law. I'm not telling you how to feel about it. I'm telling you what I'm legally required to do in response to it. If your complaint is, whatever, I only have to accommodate for that complaint.
Are you
Yeah,
ready
sure,
for
go
this
ahead.
list?
Why do I
All right.
insult
So
the
the
chat?
first thing
Someone
on my
says.
list
Well,
is
because I don't know. Chat's just like, I'm not trying to insult the chat. Just like I'm just not. I'm not gonna give
this
you the
is being
same. I'm
frank.
gonna give you the same answer every single time. It's just like, look, I'm doing a legal interpretation. I'm a legal educator. I'm interpreting the law. This is how I'm reading
Right,
it.
and that's the point.
I'm
That's the point
reading the
here. The
rule
law.
as it's written, and then I'm telling you why I think things, and then like what more do you want? I don't know. You want me to just tell you things that you
Right.
don't, I don't know what you want.
The law is black and white, and that's what
Reasonable
Kurt's
would be
doing
allowed
is a
to
black
use
and
her
white.
headphones. Giving her headphones might be a reasonable accommodation, but I'm not required to give you
But
your
reason
preferred reasonable accommodation. I'm only required to give you a reasonable accommodation. Any reasonable accommodation would be fine. Would headphones be a reasonable accommodation? Probably, but I only have to give you a reasonable accommodation. So as long as I can find one, we're
but
there.
so is attending them. So is
Right.
attending the sidebars in
So
person. That's
yes,
also
because she obviously has mobility. She obviously has the ability to get up, get down. She obviously has the ability to walk in, walk out of courtroom. She does it literally every single day. She's been doing it every single day for years. I've watched her. She can get up, get down. She can walk around. She obviously has mobility. So you can get up and approach the sidebar, therefore, is a reasonable accommodation because that solves the problem. And then we're done. We can stop talking about things. It's like, great.
Yep, leave that one alone because I agree with you on that one. So here's my list from the top just for this 2.2, all right? Sorry, yeah, it's 2.2. We've got the first due process violation in my list is tampering with the impartiality of the jury and allowing unverified accusations from a law
Yeah,
enforcement witness in the
that was
case.
sloppy at best. I agree to the point.
Right, that was definitely due process violation. 2, the judicial bias and misleading jury instructions. So basically, she shaped the jury pool to start with and confused the jury's legal obligations when she gave them the instructions on how to fill out that form. So I gave her an F on that particular thing. Like, all of these are due process violations, all fall under this rule, don't they? Rule 2.
They can do.
Yeah. Just checking. Like I said, I'm not the expert here. You are. So the allowing the destruction and tampering of evidence, digital evidence, she allowed it in. She should never have allowed that in because it was A, too late, B, it was reversed.
No, that one I'll disagree with. With respect to the fact that it's reversed, some cameras capture in reverse, and if that is just the way it's captured, then that would be how it was captured. I mean, it really was a simple problem with the way it was presented.
Well, how does she clear that up? By allowing it to be verified, right? If you allow the hash values, if you allow the defense to have access to the hash values to verify that the files haven't been tampered with, then you've cleared that up. It records in reverse because that's how it's recorded originally. That's how you do that. But she hasn't. In fact, not only has she not allowed the defense to be able to verify any of this evidence, but she also asked during a pretrial hearing to Miss Little, what would you like them to just invent chain of custody where it doesn't exist? She's more or less said in open court on the record that she knows that there's no chain of
Right, and
custody,
the chain of custody
but
issues
she's
are a real
allowed it
problem. Well,
anyway.
with respect to that, the prosecution's only required to turn over what they have. So if they don't have it, they don't have it. And the fact they don't have it becomes a problem, which relates to, for example, lab results and other aspects.
The fact is they did have it. They did have it when this was all put through court and she was charged. They did have it then, and they also had it when the charges were when the first court hearing, when she was first charged. That judge put an order in saying they had to preserve everything, and they didn't.
That's
So
not true. The
that, as
order
far as
didn't
I'm
say to preserve
concerned,
anything. The order was more narrowly tailored than that. We read the order.
right. Well, there's some disagreement on what that order covers, and chain of custody is definitely one of them. If it just says pictures, then they threw the phone away that they took the pictures with. That's
And
not preserving it.
and with that issue, the
If
phone
it
was
said,
disposed of the day before the order was signed. So there was no violation of the order at the time the phone was thrown away.
right, but at the end of the day, that evidence shouldn't come in because there's no way to
Well,
verify it. It doesn't matter if they threw it away or not. The judge is sitting there going, this evidence can't be verified. It's not in. That's her job. She's the gatekeeper. She's supposed to say whether that evidence is
well,
verified
often, no,
or not.
authenticity is at least partially a question of fact, because how can the evidence be authenticated is a question, right? There's no inherent
Well,
obligation that there be metadata inherently for a photograph. And the reason I know that is, like, I can take a photograph and I can just authenticate it because I was there. Like, that would be a way of authenticating it. It's like, did you take this photograph? Yes. Is it a fair and accurate representation? Yes. So
right,
lack
but
of motive.
the
Hmm?
digital evidence here, the digital evidence here, when they take a snapshot of someone's phone or they download the camera footage from the police department, it's wrapped up with a hash value. That's the authentication. When you're talking digital evidence, that is the authentication, and they ditched all the authentication.
Yeah.
And the judge shouldn't be allowing it in if it doesn't have the authentication or the chain of custody. So that is the rules of evidence, right? That the chain of custody must be unbroken,
No,
otherwise it's
not
tainted.
necessarily. The rules of evidence. No, not necessarily. Rules of evidence can be authentic.
Well, the federal rules of evidence is a little bit different to the Massachusetts rule of evidence.
Yeah.
So I found. But anyway, that was that point. The destruction of and tampering of digital evidence. She's just allowed it all in. Denial of exculpatory evidence. There's a bunch of Brady violations there that she's allowed the Commonwealth to get away with. Suppressing exculpatory evidence, critical to the defence. Then I also have targeting the defence's public critics, as in Aiden, for example. You can't say they haven't been targeting because they have. Retaliation against the public criticism and chilling First Amendment rights. Those are all due process violations. She's also gagged the defence from talking to the media. Then we've also got structural conflict of interest that prevents fair adjudication and deprives the defence of net neutral oversight. And this is her conflict of interest regarding the DA Morrissey's office. Prosecuting Karen while simultaneously representing Judge Cannone in the First Circuit and the habeas court. It's also concerning the entire chain of state oversight, that she's in on criticizing the DOJ for their oversight in this case, and so she's harassing this is something I've put in several categories, but she's harassing the ARCA guys, not because of their involvement, but because she knows it's to do with DOJ, and that's their oversight body. To even let Brennan stand there in court and ramble on about the DOJ like they're colluding with the DOJ, that's their oversight body. It's the DA's oversight body. It's also the
No,
judicial
it's not.
system's oversight body, the
No,
DOJ.
it's not. It's the federal government. The DOJ is the
So
federal government.
when
They have no oversight authority with respect to the state government.
no, if you're going up the chain, when we're talking about
Mhm.
checks and balances, right? The DA, let's say the DA is already under investigation for being not upfront, right? Let's say that that's what it's to do with. Who's the oversight body? The DOJ. Is that not
With
correct?
respect to what? The oversight body for the prosecutor.
If
Yep.
the DA is if the DA is doing corrupt shit, who's the
It
oversight
depends. It
body
depends
for
on the
that?
nature of what they're doing. If the DA is violating the rules of attorney's ethics, the oversight body is the state supreme court. If the state attorney is violating some sort of state criminal law, the oversight body would be the state level police. If the state prosecutor is
Right. So what
if
about
he's
civil
violating
rights?
civil rights under color of law, then it might be a federal violation with respect to a criminal law. But that's not an oversight body for the DA as such. It's an oversight body for the person who's violating the law in their capacity and with what they're doing because they're going outside their role.
Right. So when I look up how the checks and balances work, you know, because you're in the system looking at it. I don't, because I'm an outsider with a completely different. We're under
Right.
Westminster system here. We have a specific level of checks and balances here. So once you've got to the state level, just compare. Sorry, just with respect to your system, not ours. But once you get to the state level, who's oversight for the state level? Whether they are violating due process. Who's
Yeah,
oversight for that?
the question is somewhat malformed, and I'm not trying to give you a difficult time. The problem is in the United States. The problem is in the United
No,
States
that's all
system we
right.
have dual sovereignty. So the states are sovereign and the federal government is sovereign. So it's an error to say that the federal government is supervisory over the states. That's not true. The federal government's power is much more limited compared to other forms of government in the world. So like the federal government is not the boss of the states governments. The federal government's role is much more limited in our system of government. So um, and that's one of the reasons that
Right.
incidentally, like with the DOJ and the FBI investigating, like their ability to get involved here is extremely limited. Like they could
Correct.
hypothetically bring a charge against somebody for like using color of law to deprive someone of civil rights, but you know that is a limited capacity. So you know it's like when you say like, well, who's in charge of the state government? The most correct answer is nobody. The state is sovereign. They're king. So no one's in charge of the state government is the most correct answer. And then there is some minor asterisks to that. But the
Just for
correct answer is
federal
nobody with
oversight.
an asterisk. That's the most correct answer.
And the asterisk is the federal
Yes, but
government,
it's in a very
correct?
limited way, in a very narrow domain, in very limited respects, and
It's to do with public corruption,
yeah,
specifically corruption
and just
of
because
public
someone is being
funds.
denied of their rights
Right.
doesn't necessarily mean it's being corruptly done, because we have judicial review of
Right.
different systems all the time. So, like a state government might uh, not give someone a right they're owed, but that might eventually percolate its way to a federal court, which might eventually have a review. But that isn't necessarily a crime. It just might be an incorrect
Right.
application of law.
Right. Well, that I'm not suggesting it that my list here has anything to do with crimes committed by Judge Canoni. I'm just saying they're due process violations.
Well,
So,
due process violation unto itself would be just a simple like would be a civil rights violation that would trigger a constitutional review for violation of federal law, but it wouldn't trigger. But you'd have to actually like find that, and you'd actually have to find the relevant case law, and that's sort of what I do with my time because I like a lot of federal civil laws, like my domain. That's where I live. So yeah.
yeah. So I did find federal statutes that cover um, judicial neutrality with respect to DA Morrissey's office prosecuting Karen Reid while simultaneously representing Judge Canoni in the First Circuit and the federal habeas proceedings. That one I found to be absolutely absurd ethical breach. But as you say, ethics is different to
Sure,
law,
yeah,
right?
ethical obligations are imposed by the bar, and they're not imposed by the legislature. So yeah, they're different to law. If you mean morality, then that's entirely different completely. So,
I was trying not to go down the morality path because we just had that
yeah,
argument.
the
So I was just sticking to due
law and morality
process.
are completely different. Like moral arguments will get you nowhere with me, because that's not what we do in law. We do
Absolutely.
legal analysis, not moral analysis.
Absolutely.
I'm not here to tell you what's right and wrong, like in a moral sense. I'm just here to try to apply laws.
Yeah, gotcha.
As
So the
it's like
next one
it's
was
like, by
the
the way, it's exactly
suspension of
for
third
that
party.
reason that, like, when we were doing the habeas petition, I was telling my chat, as they'll be happy to tell you, I was telling them the whole time, like, this is going to go nowhere, because she just didn't have the legal argument. It just didn't, it wasn't right.
Yep.
The legal argument just wasn't there. And so people like try to say like there's something here. I'm like, no, there's really nothing here. And that's what, every federal court said, because, there's just nothing there. So,
Yeah. See, I come at it from a different, because I don't have the experience that you do. I came from it as just a strictly numbers game. This many will get seen to each year. This many will be this type. This many will be that type, and this how many of those types get through. So I think we came from completely different planets where that assessment came from. But I actually was surprised they didn't look at it because of the nature of, because of how many of that type of complaint actually get
yeah.
seen.
And I mean, it's another factor too, when you're trying to like
Just
think
by
about these things. Another thing you're trying to think about is like, what kind of these things tend to be reviewed? What tends to get criticism? What tends
yeah,
to be, so
yeah,
there's like the real politique of the thing about like what's actually going to happen in the real world. And that even narrows it down even
right,
more.
right, right. All right, so I've
Okay.
still got more of these. I've got suppression of third party culprit evidence. So the fact that she's not allowed to say that the DOJ was investigating and that's who hired ARCA, that's a due process violation. At the point where she didn't let them in, that was going to be an additional part of the due process violation, but she did let them in. So I'm going to give her a half point for that. But it was absolutely the fact that they can't say. There's a couple of things that come into this due process violation. The fact that they can't tell the jury that it's the feds, and also the fact that she wants to keep punishing them about Rule 14 violations. So if you want to go right back to the before trial 1.0, when the feds first reached out and asked the
Hmm.
defense for their paperwork, for their file, Judge Canoni punished them. She sanctioned them because they couldn't provide the Rule 14 discovery that the Commonwealth was asking for, because it was under federal order. It was the feds that had to give
Hmm.
it, not the defense. So she punished them for something that was outside of their control. And that was the due process violation. And then she continues it on. She wants to voir dire them in trial 1.0
Hmm.
as part of that sanction. She gives the Commonwealth more or less a deposition
Hmm.
prior to the testimony. That's the punishment. Then we go into pre-hearing trial point 2.0, and Frank and Hank's still freaking arguing the same points, crying about the DOJ ARCA guys. Then she's punishing them again for the DOJ ARCA guys. She's doing Rule 14 violations again for the ARCA guys. She's giving their Commonwealth depositions again for the ARCA guys. And it all stems from her original due process violation, where they couldn't provide the discovery that the Commonwealth asked for in the original pre-trial. So that's where I come from in that sense. That one's still part of 2.2. I think we were still on Rule
All right.
2.2 yet.
You want to do you want to move on to 2.3?
And then yes, there's a couple of honourable mentions still developing there, but we'll leave it at that. But those were everything that I graded an F for on 2.2.
Okay.
Sure. 2.3. Where are we? Um, so yeah, this is where I was just saying Bev hates the defense talking to the media. She's gagged them. She's like hates the media being there. I think she's okay with mainstream media, but she's not okay with just ordinary media being there. So I think
I
I
don't know
scored her
how you're going
pretty
to get
low
into
on that. I don't.
2.3 given how the rule itself defines what constitutes bias, prejudice, and harassment, because it actually then defines what it means in the comments. And I don't know how you're getting to any of
Hang
those
on.
things.
No, I'm reading
No, we,
2.4.
we can go to
Sorry, my
2.4 if you
spreadsheet's
prefer.
messed up. Sorry. It's all right. I just missed.
External influences on judicial
2.4.
conduct, how they're being swayed by partisan interest, public clamor, or fear of criticism.
Yeah. For 2.4, I had Bev hates the defense talking to the media. She's gagged them. She hates the media as long as it's not the media that like paints her in a favorable light. I don't know why I've got no 2.2
How is
here.
that being swayed by partisan interest, public clamor, or fear of criticism? You think that because
She doesn't like the criticism. That's why she's put the buffer zone in place.
But
So
how is that
I don't know
impacting
if you
her
realize
decisions?
this, but there was
She's not, how's that impacting her decisions? Other than the
it's impacting the way she's giving jury instructions. But first of all, I mean that's a long list, but it's impacted the way she's made a decision to gag the defense. They're not allowed to talk to the
that's not that
media.
uncommon.
Uh, right, but it's still a due process violation. It's the defendant's right to speak to the media if they want to.
I mean, not necessarily. I mean, again, gag orders on parties in court proceedings is not unheard of because we want things to be done in the court proceeding, not outside the court proceeding. The due process is in the courtroom, not outside of it.
I'll let you have that. I'll let you have that. But she still hates the media and she's gagged them. So that was the reason I gave her I think a middle score for that.
I mean,
one.
I don't agree that she's gagged the media.
Um,
That's not right. The media is present every single day in the courtroom. They're there live with their computers. She's broadcasting the entire trial. She's done nothing to gag the media. The media is as free as ever to say anything they want. No,
Only the
every
mainstream media.
every
She's
media,
gagged.
independent media is in that courtroom too. Turtle Boy's in the.
They're in the courtroom, but one of them's also being dragged through another court process.
But that's not her.
For reporting.
She's not doing it. That's someone else that's doing that.
But she's making decisions based on that. Okay, so during the first trial, she made the decision to not allow Aidan Carney in the courtroom while cases were pending against witnesses. But she raised in that thing, she raised stuff that had already been through a grand jury and the grand jury didn't indict. But she raised that as part of her decision to keep him out of the courtroom, even though the grand jury dismissed it and didn't indict Karen for that.
Well,
you get what I'm saying?
Just because the grand jury doesn't indict doesn't mean that doesn't give the basis of the judge to do something on the basis of it, because that's a separate question. A criminal indictment,
right?
A criminal indictment doesn't devolve the judge of the authority to do something.
Right, but it's like saying you were pulled over once and breathalyzed and then dragged into the police station because you failed whatever it is that you guys do for your roadside tests. And then at the police station, your blood came through clear that you weren't. And then the judge later on says, well, you know what? You were dragged in there and failed your roadside. So I'm going to use that as an excuse to exclude you from blah, blah, blah. That's where I'm coming from with that. Do you understand what I'm saying?
I just don't think the analogy works, with all respect. I don't agree.
It was the best one I could come up with. So, but that's okay if you disagree. But that's where I was coming from with it, that she shouldn't have used that in her decision at all. So I just worked out my spreadsheet's all bloody out of order and I can't change my columns.
Take your time.
So
we're not in a rush.
I've got formulas based on the column, so I've just got to find which one's which. Which number are we up to?
We're up to any number you want to be. We were up to 2.4, but we can go back to 2.3 if you like.
Bev's bias
Are we under
towards
2-3
the
now?
Commonwealth. 2-3, yeah,
All
because I
right.
couldn't find it
I don't
before.
think I don't think you're going to
And
get anywhere
harassing.
on 2-3 because I don't think you're going to find bias, prejudice, or harassment within the meaning of how Rule 2-3 defines those terms.
Right, when you explained how you read that rule, it kind of put me in my place. So I read them separately to the comments below, if that makes sense. So that doesn't fit. You're right. Skip 2.3. Which section do these fall into, though? The harassing the defense witnesses, which is what she's been doing since pre-trial 1.0. Which
I don't
rule
know.
does
Maybe
that
it doesn't
fall under?
necessarily fall within any rule. I'm just implying each rule one at a time. That's the way I read them. I read them one at a time, and I just tried to figure out whether the
Mm,
rule applied to each particular thing. I'm not trying to.
mm.
I'm going the other way around.
No, no, I wanted you to answer. I wanted you to answer first
Yeah.
so that
So
there
I mean,
was no
I'm not trying to
skipping
figure out
anything.
she's
So,
mean to the witness. Which rule can I cram it into? I'm trying to figure out here's the rule. What conduct does it describe? If the rule doesn't describe, if the rule doesn't describe
yeah,
any
and
of the
I went
conduct,
about it backwards.
hypothetically, if the rule doesn't describe any of the conduct, if harassing the witness, if harassing a witness was not within the scope of any rule, then I wouldn't account for it because it's not within the scope of
Yeah,
any rule. I can only prohibit what the rule
yeah.
prohibits.
So I went about it completely backwards because I had my list of due process violations and biases listed, and I was like, which rule do they fit into? And so that's probably why I came up with things that don't fit into that rule, if that makes sense, because I went about it
Yeah.
backwards. So I'm just not going to read any more of my responses to compare because I'm pretty sure I got them in the wrong spots. Well, the whole point of going through it with you is to actually work out which spots they should have gone into, to
No, I
be
mean that's
fair.
fine. I'm fine. And,
When it comes down to that harassment that I described of the ARCA witnesses, which
well,
rule
I
would
think
you
that's
fit
where I
that
put it
into?
in 2-2 is where I put it because the unfairness and ill treatment is where I put it into D was why I gave her a D because of how
Right.
harsh she is to the defense.
Okay.
Yeah, the lack of fair. Yeah,
Right.
uphold the law and shall perform duties fairly and impartially, objective and open minded. Um, so I'm like,
Right.
that's why I
Right.
gave her a D. I think is in 2-2 where that kind of thing was implicated.
Yeah. So this is helping me too because I don't know that the audience is going to understand the how to put it into context with the way the question format is either. So this is helping me out with like refining the process. Nobody else has filled this out
That's
yet.
okay. I'm sure
So
everyone will
maybe I should
disagree with me
refine.
massively. That's fine.
Well, I think people go about it more like I have. Like they've already got all these violations in mind and try to fit it into
Yeah.
the framework of how I presented the form. So this just helps me sort of work out how to present the form better, I
I mean,
guess.
this is the way I always do
Which is
everything, and my channel knows this. Like, I try to interpret every legal issue and every issue unto itself by its own terms. So, like for example, when the judge denied the motion to dismiss for extraordinary cause, I thought she was right. When the court failed to give the habeas, I thought they were right. So like I just try to assess each issue unto itself and just like, okay, that was correct or that's a mistake. Um, I think a
yeah,
lot of people are frustrated by the process. A lot of people, especially, don't think Karen Reed should be prosecuted. I don't think she should be prosecuted at all. So, like, the fact she's being prosecuted is frustrating, but I don't want to use that bias. I don't want to use that bias to, come up with the wrong answer on the rule. I want to try to. I want to try to. I
yeah,
want to try to
yeah.
apply the
No,
rule
I get,
correctly.
I get where yeah, I get exactly where you're coming from, and I have to admit I am biased because I don't think I
I don't
just
like the
don't
judge
like the
either.
judge. I
I don't like the
just
judge either.
I don't at all.
Anyone who thinks I like the judge definitely is not paying attention. I have many, many sharp criticisms for the judge. The disparate treatment between the prosecution and
Yeah,
defense is manifestly obvious and disheartening.
right. And there's also there's also things that I would be judging that you probably necessarily wouldn't. Things like the other day when Brennan nodded at her, and for some reason that was a message for her. Did you see that snippet? I'm sure everyone pointed it out to you, as everyone
I mean,
does.
I'm not sure that I really noted that in particular, but the fact that Brennan is the golden child, I think, is apparent to Brennan as well. So the fact that he is expecting a certain
Right.
level of treatment is obvious.
So to me, I just assume there's ex parte communications going on there, because how else would she know what that head nod meant? You know what I mean? How else would she be able to read his body language and know
She
what he
knows
meant by that?
she knows
None
what
of
it
us
means
knew what the
because
hell.
she likes everything the prosecution does and doesn't like anything the defense does. So that's how.
Right. Yeah, and so that's the reason that I look at it all completely different. I'm not in your field, obviously. I am just a viewer. I'm just an audience member who creates content based on what you guys say, and I listen to what all of you say too. So that probably puts me in a little different category to just a general audience member, because I know you've all got your own niches. You and Andrea in a different level of court to, say, the defense attorneys, and then Melanie Little's in civil, so that's a different court again. So I also understand those differences between what you're all saying and why you're saying what you're saying, if that makes
As long as
sense.
people understand
So
why, I
uh,
always just want my chain of logic to be understood. I want people to understand my priors or my axioms, I suppose, and I want them to be able to follow me through the entire chain of logic so that they understand what's going on. And then you can sort of
yeah,
understand everything. But yeah, I mean,
right.
I think Andrea, I've listened to a little bit of Andrea's coverage on this, not a lot, but the little snippets I've heard of Andrea, it seems to me that we broadly agree relating to, like, for example, how the prosecution is doing, how the defense is doing. It seemed, based on my impression at least, we broadly agree.
Hmm.
I think that I definitely think I'm more in the minority, or maybe Andrea and I both are maybe more in the minority with respect to our relative assessments of the strength of the prosecution defense. I think LawTube as a whole seems to be more critical of the prosecution, more favorable to the defense. So I am, and perhaps me and
Mm,
Andre are sitting a little bit apart on those elements. Um, but it's like, yeah, I don't think Karen Reed should be prosecuted. I think the whole thing is a joke. I think that the state's evidence. It's like this is my frustration, trying to get people to understand like how I can think these things at the same time. Because to me, there's no conflict. It's like, because I do think genuinely, I don't think she should be prosecuted. I think the state's evidence is a joke. I can't believe they're prosecuting this. The evidence collection is the stuff of nightmares. The issues with the lab, the issues with the logs, the issues with not finding the pieces of plastic and the solo cups and the leaf blowers and the rakes and oh, I just
right. At the
magically
end of the day,
discovered these pieces of plastic one day, although no, the homeowner never did. They never came out that evening. Like, there's bullshit being
yeah,
said in so many different places in this trial. It's like hard to keep track. But I think some people have a hard time with me, like, how can you think all those things and also simultaneously think that the judge was correct to not dismiss for extraordinary cause? And to me, it's like, well, because that motion has a legal standard that I don't think is being met. It shouldn't be dismissed for that reason. It should be dismissed for some other reason. But I think sometimes people have a hard
right.
time appreciating these delineations I'm making.
At the end of the day, if you are a lawyer, you don't really get a choice in the state of your case. You just got to make lemonade out of
Yeah.
lemons. Really, that's all you
Yeah, yeah,
can
yeah.
do, right? You don't get,
Well,
it's
except
like,
if you're the
I'm just not
Commonwealth, because the
taking this
Commonwealth
job.
doesn't have to prosecute. So that criticism is mostly fair. But with the
Right,
with the Commonwealth, because they're the government, they have extra special obligations just for them, which is like, to seek justice, not just
right.
convictions, and don't bring bullshit to court.
So it's fair to apply that to Brennan and Lally, but not so fair as far as the DA is concerned because he's the
Right.
one that makes that final
Yeah,
decision, right?
this case
Yeah.
is in shambles. Like, why how you're able to bring this case with a straight face is beyond me. Because Jen McCabe said
Yeah.
I
Yeah.
heard I hit him, I hit him, I hit him. That's basically what you're it's like even if you think Karen Reed said that, I'm still back with, well, she said it basically in a panic. She said it, just having discussed her
Yeah.
boyfriend as she's trying to make sense of reality. She's probably, you know, she's probably just completely mentally gone and has absolutely no concept what she's saying. So, like, why would you give it any credibility anyway? Well, this is the strength of
Mm.
your case, this supposed admission, which I don't think is worth anything in the first place anyway. Even if you assume it happened, it's bullshit.
Hey, on that note, how do you feel about the prosecution showing those clips with nobody on the stand to
Well, I mean, I
cross-examine?
think it's tactically very wise by them. I think the defense perhaps made a mistake in allowing that because they could have insisted on that evidence being authenticated and bring in witnesses to slow that down. So but yeah, so I think that
Mm.
was perhaps a mistake on their part, but
Is it that they
it must be they
stipulated that, or
stipulated
is it
authenticity. It
that
must be.
the right, because when I was looking up how that works, agreeing to the authenticity is a totally other thing to agreeing to it being shown without a witness on the stand. And I feel like they might have got tricked there by agreeing to the authenticity.
And
Does
perhaps,
that make sense?
perhaps. Yeah.
And now they're stuck with it.
I think they've been using those clips very effectively. I really like the way that they're doing that. If the prosecution, like bringing those clips in, like to break out their witnesses and like use Karen Reed's own words as much as you can, basically to bring them in little by little.
Yeah.
I think it's tactically
I
genius.
don't think I think tactically they drew the better straw, but on the same token, I feel like it's still a violation of due process because there's no one to cross-examine.
Yeah, well, I mean, as to that, their statements from the defense's own mouth. I mean, the defense would be able to bring in as much. Well,
Statements of
yeah,
an
statement of
opposing
opposing party. The
party.
defense would have the right to play as much of the clip as they want. So if they feel that the clips are being brought out of context, the rule of completeness gets them there. So they have the right to play as much of the clip as they want. So if they want to play more of the clip, they certainly can do
Right.
that, and they can do that in their case if they feel that's prudent.
So my original thought was if the defense team knew that those could be used against Karen, which obviously they do, they're very experienced attorneys that didn't not guess that, and they do have rule of completeness in their favor, they could bring it in as in closing arguments without playing by just playing either side of that the sentence either side of that clip to give
Well,
it the context, right?
they wouldn't be able to do it
Without
in
having a witness
closing
on the
because
stand.
closing you can't introduce anything new. So they'd have to at some point in their case in chief
Yeah.
play the clips in full, and then they could refer them back in closing.
So we'll see there's no point they can play them in full. They can only play the sentence, the full sentence. They
Sure, they
can't
can.
play the full clip at
Sure, they
any
can.
stage.
Yeah, I mean, that's
You
rule
sure?
completeness. If the prosecutor has the right to bring in part of it, they should have the right to bring in all of it.
Because as far as I understood it, it's like 40 hours of clips that they collected. So I can't see how the judge is going to allow that, if that makes sense. She's only going to allow them to play, the full sentence for completeness, not the entire clip.
Mm, I mean, they should have the right to bring in the entire thing if they want. I mean, the judge might be able to narrow it down a little bit, but not to just the sentence. I don't think that makes sense.
Yeah, and what's the why can't they do it in
Well, they
closing?
can't do it. They have to introduce the evidence at some point in order because you can't.
Yeah, well, the prosecution's producing
They're
it
introducing the
in
clip.
between.
So if you want to bring in other
Yeah,
things, you have to introduce the thing you want to bring in before you can bring it into closing. You can't introduce things. You can introduce
but isn't completeness to do with the whole sentence that she said?
No,
Like, they're clipping
completeness
partial
is for the
sentences.
entire interview. Completeness is for the entire video is completeness.
So, if completeness applies So I'm confused. Does completeness not apply in closing?
They need to bring in what they want to bring into the closing before closing. So if they want other parts of the video, they have to bring it in at some point prior to closing.
Right. So they could call, for example, Gretchen Voss to the stand,
They don't
ask her,
have
"Did
to.
you
It's already been
film this clip?"
authentication's been
And then
stipulated to. This prosecution's already played the clip. They don't have to do that. They could just play the video.
so how would the defense now complete? How would they bring in
They
completeness
during their case in
now
chief, they would have the right to play as much of the video as they want. Right.
without a witness on the
Sure.
stand, just the same way the prosecution is? Ah, all makes
Yeah.
sense now.
Yeah.
Thank you. That I was confused
Yeah.
about how they would go about it. Like, I
No,
knew
it's
they
no
could, I
problem
didn't
because
know
everything
how.
else has been done. Like you already have foundation's already been done because the video is being played. Authentication's already been done because the video is being played. Right. And so, like, okay, so now I can just play the entire video. So I could just play the entire video at any time. I don't need a witness on the stand because I already have authentication. I already have foundation. The only thing maybe I have an issue with is relevance, but they've already played a clip, and so they've already established relevance. And so maybe the judge can narrow that
Yep.
down a little bit and be like, you can, it's like, play some increased segment of it. But yeah, I mean, the typical rule is like if the prosecution wanted to play 20 seconds of a 3-hour long, police interrogation tape, if the defense wanted to, they could be like, okay, let's watch all 3 hours and just play that beautiful beam
Yeah.
footage, and we go forward with our lives.
Well, we know Beeb's gonna stop him. She's gonna go, "No, you can't." But, within reason, I think
Yeah,
she'll let them go. So that
yeah.
answers that question. Um, so someone asked a question in chat, and it was way back, but I wanted to know how you felt about it as well. When she's the one doing the questioning of the witness,
It can be
is that
proper.
proper?
It's an interesting style.
Seems terribly improper to me,
Well,
but
the judge is allowed to
explain.
ask questions as a standard rule. The judge can ask questions as long as they do it in a neutral fashion. Judges typically don't. Judge Canoni uses them for the purpose of restating or clarifying the question to avoid a little back and forth. So, like, basically, what happens is someone asks a question, there's an objection, and so basically she rephrases the question to provide it in the unobjectionable form in order to save a little bit of back and forth. So, I mean, that part is not
Yeah.
inherently.
So you think that's what she's doing?
I think it's how the Court of Appeals would view it.
But you don't feel that that's what she's doing if you weren't the Court of Appeals, just in your own opinion? Or do you feel that there's been some stepping outside of those bounds at some stages? Even though we know the Court of Appeals is always gonna
I
rule
tell
in
you
their
what,
favor anyway,
at
but
times I would have been even harsher about the judge than the judge about things. Like with Jackson, for example, in that cross of Jen McCabe, I would have probably shut his ass down a lot faster than the judge did because of asked and answered. Like we've already been over this ground. It's like if you have nothing new to ask, your cross examination's over. And if he got up and insisted, if he got up and
she asked for
yeah,
it. She's asking for it because she's not letting them state objections. So they've got to guess what the objection was. And so she's asking for that in that sense. If she allowed the objection to be stated, the grounds for the objection to be stated, then he probably wouldn't be pushing it that far, if that makes sense. It's kind of a two-edged sword, right? You either don't let objections
I'm not
be
talking about the
stated,
objections. I'm talking
and
about
then
how Jackson, when he doesn't get the answer to the question he wants, will just keep asking the question over and over and over again until like he just keeps asking the
right,
same question over and over again. I'm like, asked and answered. You asked the question, an answer was given. It wasn't the answer you wanted. Too bad, so sad. Move along. And so, if it were up to me, as the
right.
judge, I would. If
That's what she should be saying. That's what she
yeah,
should be saying, but she's not because she doesn't want the objection to be stated on the record, even if she's the one doing it.
well, yeah, she should be saying asked and answered. Move on.
She should be,
And
yeah,
then when
I agree with you. So I
when
kind of
Jackson's
feel
being
like
and if
her own
Jackson got up there
two-edged
and being
sword.
and was like insisting, and if you were doing that in my courtroom, I'd be like, okay, cross examination's over now. You can sit down. because I have the right. I have the right as a judge to to do that. And it's like if you have nothing new to add and you just want to be a bitch and argue, you can be a little bitch there and sit down, sit at the defense table, be a bitch and be sad. But I mean. So
Yeah.
don't come to,
I
don't
get
come to
I
me
get
for
where you're
relief.
coming from though, but I still feel like she made her own bed there because the if the Commonwealth wants to object because Jackson's doing that, then the grounds for the objection is what makes Jackson realign what
Sure.
he's doing. Do you get what I'm saying? So she's not getting that flow happening because she's the one who caused them not to be able to state objections in the first place. Even if she says asked and answered, it's now on the record that there's an objection and she's making it. So I kind of feel like
Yeah.
she cut her own nose
No,
off to
yeah,
spite her face
that'd
there.
probably be me. I'd be making my own objections as a judge. I'd be like asked and answered. Next question.
Yeah, yeah. Do you feel how do you feel about her not having the grounds for objection
Yeah.
stated
Also, I find
aloud?
that a little bit frustrating as a judge. I'd probably allow speaking objections because I just don't like the going back into sidebar. I just find it too disruptive. So I'd probably just allow them to state their objections in open court in front of the jury and basically be like, "Fuck it, I don't do sidebar. I
Well,
don't do
there's a
sidebars. I
difference
don't do
between
sidebars."
there's a difference between stating the grounds for your objection and speaking objections. There's a difference between the two. So just so
That's
the
fair.
audience doesn't get
That's
confused,
fair.
because
Yeah,
those are two different
I could
things.
just say like, just simply say objection, state your grounds, and be like, and then if I need
Yeah,
anything more, then I can yeah, I can just
yeah.
instantly rule on it because I can
Slide
instantly rule
back.
on the objection, like objection, asked, answered,
Yeah,
sustained, or
yeah,
overrule.
yeah, exactly. Yeah, I found it weird, and it never really clicked to me as to why she would do that until Andrea explained it. It's actually an appellate kind of thing, so it's not spoken aloud on the record, and it gives them some what's the word, deniability when it comes to
Yeah, I don't care about
an
the Court of
appeal.
Appeals. They can bite me. That's fine. I made my ruling. I made my ruling. Let's go. Yeah. The Court of Appeals
Right.
is
Well,
not out to
it just
overrule judges just for the hell of it. So
right.
yeah.
So whether it's spoken or not, it
I
doesn't
think some
matter.
judges don't like it because they don't want the objection or even the speaking objection to prejudice the jury. I think they're concerned about that. I'm like, I can't be bothered to care. That's fine. You can make your legal arguments in front of the jury. That's fine. I
Yeah.
can't be care.
You think that's her
I
motivation?
think it's a stylistic thing. Some judges like it and some judges don't. I think if she just does that in all her cases, it's stylistic. Just as much, incidentally, as some judges care about certain things as other things. Like, for example, I'm probably not as strict about foundation as some judges would be. Like, I find foundation is
Yeah.
just like, it's just not something that like I find to be as important. So if I were a judge, and you made an objection foundation, I'd be like, yeah, that's probably not going to work with me. Foundation objections, probably not going to work. But there are things I might choose to care about more because some judges care about other things more than other judges. It's just stylistic, what do we care about? What don't we? It's part of the human experience. We're human beings after all.
Yeah. Yeah. Well, I have watched a lot of criminal trials in the 2 or 3 years that I've had my channel, and I have never seen a judge not allow them to state the
That's fair.
grounds.
Yeah,
for their objection. Never
yeah,
seen it
not
before.
even stating grounds on the record is definitely an interesting one. You should at least state the grounds, and the judge should be saying
Right.
overruled or sustained. I don't. Yeah, judges should probably be like the way she does it with the
We let them have it.
it's like with
We
the
let him have
rephrasing.
that
Is that an
one. It's
overruled? Is that
terrible.
sustained? It'd be like I'd be like I could even you could be like objection like leading. I could even be like sustained, and then I'll just ask the question myself in a non-leading format. I could do that, but yeah, she's not doing that.
Yeah. Yeah, it's very frustrating watching it, and as I said, I think that makes her way less likable for this type of exercise in filling out the form that I've got. So it's still an interesting
Judge Bev
exercise.
has
I thought it would
many
be fun.
problems. She is not a fair judge. The way she treats the defense like they are dog shit and the way she treats the prosecution like the fucking golden
Mm.
child is incredibly infuriating.
I think the frustration for me is the reasons that she's doing it. The reasons that she's giving don't match with the punishment, if that makes sense. I feel like she thinks that the candor with the court was, lacking. So her punishment for that, I feel like her punishments don't match her reasoning for issuing a punishment, if that makes sense.
Makes a lot of sense to me.
Yeah. Do you feel that too?
All the time.
Yeah. It's interesting. Well, there you go.
This has been an interesting and somewhat contentious discussion, but I had fun.
I had fun too. I don't know if the audience did, and I'm sorry I didn't even take notice if the audience was enjoying it, because I can't see the chat from this perspective. I can't see what's going on in the chat. So I hope they did enjoy it.
They've approved unreservedly of every single word I've said. They just agree with me in every possible way. They think my brilliance is beyond comparison. They can't believe that other people are unable to see things. They're truly embarrassed for all the others who don't get it.
That's so funny. What I hope we can do here is demonstrate that we don't necessarily have to agree with each other, and we don't necessarily have to be hateful and hurtful towards each other because we don't agree on something.
Yeah, I don't hate you. I like you, and we agree. We agree a lot more than we disagree. I mean, we did, to the extent we disagree. We disagree on technicalities, like which isn't nothing, because laws are technicalities. I mean, that is my field. It's kind of my job. But like, yeah, it's like if you said I don't like the judge, it'd be like, I don't like the judge either. If you said she's biased, I'd be like, yeah, she's biased. And then you said, well, it's rule 2-4. I'm like, no, it's not. And that's where we have the fight, right? It's something else, but yeah, it's fine.
Right. That's what I find most difficult to deal with when it comes to the audiences, because if they don't agree on something, they seem to see it as something personal. And I just want people to know it doesn't have to be personal. Like, you can still come here and watch Kurt's channel if you don't agree with him on something. Like, there's no reason for you to have that, well, I'm not watching that creator anymore because they said something I don't agree with. That's silly. So, but I hope that we set an example today that we can disagree on some things and agree majorly on other things
anytime,
and still get along. So, important message for the audience.
Well, I want you, before we head off, why don't you plug your channel? Tell us a little bit about what you're covering, where people can find you. Where do we find you on the social media? What kind of content do you cover? Why would we want to watch you? Tell us more things.
Well, I don't know why you'd want to watch me. I'm pretty much of a newcomer to the scene. So, but I have been following Karen Read case since Aidan Carney first got locked up. That's why I actually caught my attention. And my friends actually read through the police report on their channel. And so I do cover the Karen Read case, but I also cover other cases where I don't make friends, obviously, because I don't always go with the flow. But most popularly known for mashups. So I do the LawTube mashups. I grab all of the comments where I think it's funny, or it's at least uplifting, or at least distracting, so we don't have to get into the weeds with everything. And my channel on all of the social medias is Aussie Insider. If you're looking for me, at on Aussie Insider. Although on X, they let me use Aussie Insider, but I'm at Mesmerelda 007 on X. But yeah, I don't do too many lives. I'm mostly short attention span type videos, 5 or 10 minutes. But we are doing vent streams at the moment, because I find Judge Kanani so frustrating after a court day. I need to vent. Yeah. So you're welcome to join us on a vent stream if you feel like venting at any time.
I could use a vent stream sometimes. What times are those usually at?
Usually by about 5 or 6 p.m. after court. So court finishes around 4 p.m. So I usually give it an hour or two, and then it depends on how frustrating she is. Sometimes I go off a little bit.
Do you have a segment where I can yell into the void?
you can yell into the void.
Excellent.
That's exactly what we do. We're always yelling into the void. And you can also correct me on things when I'm researching, answers to things. Like, for example, who's the oversight body when everyone's out of freaking control like this? Uh, I do need, that extra input because I can only find out so much
Yeah.
through Google and Chat GPT.
I,
So, but yeah, it'd be
I
awesome
take
to
I
have
take
you on.
federalism very, very seriously. So when you're like the feds are the boss of states, I'm like, no.
Well, I really need to know more about the federalism side of it because, we are a federalist kind of. We're
Mm.
supposed to be a federation, but we're not as federal as you guys are. So I
It
need to
is it
learn a
is
lot more
it
about
is
that
it's a
side of it.
weird
Would
system
love
of
to have
government
you on.
compared to other countries. It's strange. It's the easiest way I can have to describe it is kind of like the border about like when do you stop becoming a country is kind of an interesting thing. So it's kind of like the EU, I suppose, in some ways, except it's even more. So like in the same way that like the EU is not really the boss of each country in the European Union. It's kind of like that. Although obviously we're more integrated because we don't think of like Texas as a separate country in that respect. But it's like so that line between like how integrated you are or not. It's like, well, we're more integrated than the EU, but like not as integrated as like, I don't know, some other countries. So it's interesting. Yeah. So it's
Commonwealth.
somewhere in between.
Yeah. Interesting. Well, I would love to have you on sometime so we can talk about this federalism stuff and sort my brain out on how that
Excellent.
actually
Well,
does
I
work.
have been
Would be
enjoying
awesome.
you, and please make sure to check out my friend's channel, Aussie Insider, and all the places in social media. Thank you so much for joining us. All right.
Thanks for having me. And thanks again,
All
chat,
right.
for the
We'll
warm
see you
welcome.
soon. Thanks for coming. All right. Bye bye. All right, my friends, that was Aussie Insider, and I'm very glad that she was able to spend some time with us. Sorry for earlier in the stream. It's interesting when you have a guest on. I was sort of like talking to chat and then also talking to her. And then I wound up kind of talking over her because I was talking to chat. And, it's been a while since I haven't really done an interview in a while. So I got the balance wrong. So I apologize to my guest, especially in the early part of the interview where I was like trying to deal with chat and trying to respond to things and kind of got the chat wrong. And then also at some point, I'm like, you know what? What if I just ignore chat completely? And I think that was a more successful endeavor by just ignoring chat completely for like the last hour. So first 20 to 30 minutes, last hour worked out better. So all those things worked out okay. It was a lot of fun. And yeah, it's like, yeah, we can all agree that the judge is a dick, but maybe we don't all agree the judge is a dick for the same reasons. And then as we're trying to apply the rules, which rules do or do not apply, is an interesting, if perhaps frustrating endeavor for us all. As I try to like read the rules with the precision and be like, okay, this rule does or does not apply, even if I think the judge is a dick. So fun times had by all. But I'm sure there are other people out there who, including lawyers, who would assess things differently. So maybe we'll have a discussion with one of them at some point, and we'll have a discussion with another lawyer, and then we can really have an argument. We can really have a fight where we do our mage fight, our mage fight with our casting the different spells and see, who's going on, and could be fun, and who reigns supreme, who doesn't reign supreme, so forth and so on, and all those good things. Good times had by all. All right, well, my friends, I need to continue doing my laundry, so that's fun. Oh yeah, Miss Mandy just said ask her about the AI tool. Well, it's a little late, Miss Mandy. Sorry about that. Apparently, she has an AI tool that I don't know about. Mandy, can you tell me about the AI tool? Can we see the AI tool? I will talk about it. Is there a way for me to find the AI tool? As we wait for Mandy to hear me, as here's the disembodied voice from the beyond. As I contemplate my laundry needs. I took out a whole bunch of stuff today. I had to do trash today because I had all that stuff for my PC build kit. So I got like one of the larger sort of lawn trash bags, and I somehow managed to fill it up with various boxes and stuff, and took that out to the dump today. So that was an accomplishment. And then I cleaned off my tables and cleaned up my bookcase. And I'm working on laundry as we speak. And I even like did the floors a little bit, although I need to do them again. To be honest, they're still a little dirty, but they need some more love. But that's okay. We'll give them some more love. No, she shows it. All right. Well, never mind. All right. Well, then another time. Sorry about that. Laundry needs, and then I think it's some time later today. I'm thinking about playing. It's called Crime Scene Cleaner. I thought that'd be fun. We play the role of a guy who made a bad deal with the mob, and then his job is to go to the places the mob has done their mob things and clean up the crime scene. So I thought maybe we could play Crime Scene Cleaner and clean up some bloody mob crime scenes, and that could be entertaining. Maybe we'll do that today. So that could be exciting. All right, guys, I'm gonna sign off for now. I love you guys. Until later, my friends. I hope all's well. Cheers for now, my friends, and goodbye. Where's the button? Do we have outro things? How do I do an outro thing?